Welcome back to the Canada Central YouTube channel. Today, we are diving into a topic that can be incredibly frustrating for many of you: immigration refusals. If you have ever dealt with an IRC refusal, you know exactly what we are talking about. Those letters can be downright useless. They give very little information to help you appeal your application. So let's break down your options on what to do when faced with this situation. Essentially, you have three main paths forward: reapplying, requesting a reconsideration, or challenging the refusal in federal court. You can choose one, a combination of some, or all three, depending on your situation. Let's get down to explaining each option. 1. Reapplying. A fresh start. This is often the most straightforward option. You correct mistakes, provide more evidence, and submit a new application. For instance, if your visitor visa was refused due to insufficient funds, you can show that you have more money now. Or if your ties to your home country were questioned, you can provide more proof of your commitments there and that you plan on returning home. However, vague refusal letters make this a bit tricky. We often have to dig deeper to understand the immigration officer's perspective. That is why we recommend requesting the GCMS notes, which provide more details. But beware, this can take weeks or even months to receive, and you only have a limited time to challenge a refusal in court. So why choose reapplying? Because it's a simple, relatively cheap, and quick option. But it might not be the right option for everyone, especially if you're ineligible for a new application or the program you applied for has expired. 2. Reconsideration request. A second look. This is a free option, but it is not guaranteed to work. You write a letter explaining why you believe the officer made a mistake and request reconsideration of your original submission. It is most effective when there is a clear error, like misinterpreting your status. The downside is that it can take forever to get a response, and there is no obligation for the immigration officers to change their mind. 3. Judicial review. Fighting back. This is the most complex and expensive option, with tight deadlines. You have 15 days if you are already in Canada, and 60 days if you are still outside, to submit an appeal request to court. It is a two-step process: getting leave, permission to apply for judicial review, and then the actual court hearing. The court does not and cannot approve your application. It just sends it back to the IRCC asking for a new decision. This process can take over a year. Making a deal with the government is often an option to avoid court, but it is not guaranteed. Judge an offer carefully if you get one. So, there you have it. Reapplying, reconsideration, or judicial review. Each has its pros and cons. The best approach depends on your personal situation. If you're considering challenging a refusal, we recommend that you book a consultation with Canada Central. Our experts can help you navigate your options and create a strategy. Thank you for watching. Please don't forget to like, subscribe, and leave your questions in the comments.